You're welcome to another session of the Public Policy Dialogue. My name, as you have been told, is Adiola Oshifeko, and I'm the moderator for this session, which I think is a very, very interesting and timely one, because I'm sure we're all aware that there's a buzz of conversations and narratives about accessing capital. But this session is going beyond that phase to how to unlock trapped capital through judicial reforms. We all know that capital is the lifeblood of any economy, which facilitates not only business growth, but also provides public institutions with funds for infrastructure development, social amenities, whilst ensuring the delivery of basic services. However, capital could sometimes get trapped. It could get trapped in endless disputes. It could also be entangled in regulatory red tapeism, and sometimes also lost in weak enforcement mechanisms, which makes the users of the law lose trust in the legal system. As Leonard Silk, Mr. Swaro had earlier said, that law always interacts, with other disciplines. This session is also going to be merging economics as well as law. As we dissect this conversation, we'll be looking at how the court can be a lot more fairer, efficient, and predictable in order to regain the trust of investors, as well as signal business readiness to the entire business community in Nigeria. To make this happen, we're going to be talking about how bold ideas integrated in reforms would be aligned, or should be aligned rather, with legal, judicial, banking, and regulatory frameworks, anchored in due process, transparency, and efficiency. Reforms that are targeted to faster and better enforcement of judgment and arbitral awards, and discourage unnecessary challenges that derail legitimate outcomes. Equally important are institutional upgrades. We need upgrades for smarter coordination, digital tools that can eliminate delays, and specialized commercial courts. When we clear these bottlenecks, we're sure to set capital free, flowing into the systems that need to power progress. Because when capital flows, everyone, including the businesses, the government, and the citizens win. As we proceed into this conversation, I'd like to let you know that we have a balanced panel representing both the public and the private organizations who will be doing justice to this conversation. To join this conversation, we have the panel chair. Our panel chair is no other than Honorable Justice Olayinka Faji. He is a respected jurist with a distinguished legal career. He initially began his practice in the maritime sector, and he was later elevated. He was later elevated to a High Court judge. He has served in 6 different federal jurisdictions, and he currently heads the Lagos division as the administrative judge. Honorable Justice Faji is a sought-after international speaker. He's going to be sharing insight on this policy conversations as the keynote speaker, as well as doubling as a panel chair. Beyond the courtroom, Honorable Justice Faji is an avid choral music lover and poet. Please make welcome to the podium no other person than Honorable Justice Faji. Our next panelist is a distinguished solicitor and advocate of the Supreme Court of Nigeria. He is currently the head of the Legal Services and General Counsel at the Union Bank of Nigeria PLC. He's currently a member of several professional institutions and a past chairman of the Association of Banks, Legal Advisors, and Company Secretaries. He's also a member of the Institute of Directors. Mr. Sheson Shobowale brings deep insights, integrity, and strategic acumen to the evolving legal and corporate governance landscape. Please also welcome him to the stage. The next panelist is Mr. Kehinde Daudu. He's a leading corporate lawyer, mediator, and currently serves as the Chief Legal and Head of Legal and Regulatory he serves as the head of the Legal and Regulatory Officer at the Eco Bank of Nigeria. He's recognized as a Legal 500 Power List General Counsel. He serves on the Corporate Counsel Forum Committee of the Nigerian Bar Association. Mr. Kehinde is known for delivering commercially driven legal solutions within high growth, cross-border environment. Please make welcome Mr. Kehinde. And next we have Professor Pius, who is a professor of the banking law and immediate past provost, dean of law at the Babcock University. He is the current president and chairman of the Council of the Chartered Institute of Bankers of Nigeria and a fellow of the several professional bodies, including the Institute of Capital Market Registrars, Chartered Secretaries, and Administrators. He is a prolific scholar. He has authored several books and published 76 academic papers. Please welcome no other person than Professor Pius Oladeji Olariwaju. And finally, we have a moderator who also doubles as a panelist in this session. She's a partner at Petchton & Gray, a leading firm in the banking and finance sector, and also our headline sponsors. She holds a master's degree in oil and gas law from the University of Aberdeen, Scotland. Her contributions have earned her accolades, including the 40 on the 14 Rising Stars recognition, a World Bank certificate of recognition as a national expert by Lexology. Beyond her legal work, she's a thought leader, publishing insightful articles, in Business Day, Mondac Lexology, and is going to be moderating this session, Beyond Capital, leveraging judicial reforms to unlock capital. At this point in time, I'll be handing over the reins of the conversation to our moderator, who is no other person as Ms. Tare Olorogun.
Hello, ladies and gentlemen. Good afternoon. I was trying to use, I know this is beautiful, but I was trying to use this because it's easy to navigate. But I just want to say thank you to the organizers of this conference, the planning committee, and also to the MBA leadership for the opportunity to be the moderator of this forward-thinking session. This session is actually timely in light of the fact that the banks are currently undergoing a recapitalization and also applying the Basel III framework. So it means that banks would need to work optimally in order to impact the real economy. So this session will be discussing three key areas. The first is judicial enforcement, the second is standardization of banks' documents, and the third is innovative financing structure for banks. In order for us to do this, we need to have a opening speech from the chairman of the panel, my Lord Honorable Justice Faji. His discussions will give us a limelight into what we're discussing as a panel. My Lord, over to you.
Good afternoon, ladies and gentlemen. It's not all the time that you are a chairman and panelists on the same rostrum, but that is where I find myself today, and I want to thank the organizers, particularly the Nigerian Bar Association Lagos branch, for asking me to come here to expose some of my thinking about this rather esoteric area of human endeavor. Finance and banking are things that are very, very close to us, right in our pockets. The theme for this session is Beyond Capital, Reforming the Courts to Unlock Capital and Drive Growth. I have a short speech that I'll present, as it's a pleasure to welcome you to this important and timely session. As Nigeria's financial system continues to evolve, especially in the wake of the CBN's recapitalization directive, we are reminded that increasing capital is only one side of the equation. Equally critical is how that capital is utilized and how effectively the system supports its deployment to the real economy. We face undeniable structural challenges. These include the slow pace of judicial processes, the absence of a coordinated regulatory framework for advanced banking transactions, a lack of standardized documentation practices, and limited flexibility in how banks can optimize their balance sheets. All of these hinder capital mobility and ultimately economic growth. Our conversation this afternoon is set against this backdrop and centers on practical legal, judicial, and regulatory reforms that can enhance liquidity, unlock credit, and strengthen investor confidence. Within this context, it is important to acknowledge the increasing complexity of banking transactions. Concepts such as novation, assignment, and sub-participation are not just legal terms, they are fundamental commercial tools that allow for the transfer and restructuring of both performing and non-performing assets. These mechanisms are the heart of modern banking and are essential for freeing up balance sheets and enhancing capital efficiency. The ongoing recapitalization exercise has further underscored the urgency for banks to adopt innovative strategies in managing their risk-weighted assets. However, for these innovations to be meaningful and sustainable, regulators must play a pivotal role in providing the enabling framework. Likewise, the judiciary must be equipped with the tools, training, and institutional support necessary to interpret and enforce these increasingly sophisticated financial arrangements. Ultimately, this panel is not simply about reforming contracts or tweaking court procedures in isolation. It is about recognizing the need for alignment among all stakeholders, banks, regulators, legal professionals, and the judiciary. Only through stronger collaboration can we hope to build a financial system that is efficient, inclusive, and responsive to the country's development needs. I therefore look forward to hearing from and sharing with my co-panelists, distinguished panelists, and trust that discussions today will inspire meaningful progress across all sectors represented here. Thank you very much.
Thank you very much for that speech, my Lord Honorable Justice Faji. It has set the tone for the conversations that we'll be having on the panel session. And I'll just give the structure of how this session is going to run. So we'll have conversations on the panel, so questions that will be thrown to the panelists and then their responses. Afterwards, we'll take questions from the audience. So if you have your question, please, you can pen it down. I know that we have a mic in the middle and not everyone is bold enough to work to the middle of the hall to ask questions. So if you know that you might not be able to do that, you can write your questions down and our MCs would bring them here. But if you can, we would like you to walk forward and ask your questions after the conversations that we'll be having here. Okay, so I will just go straight to the questions that I have for the panelists. And like I said before, this discussion is actually timely in light of the recapitalization mandates that the banks have. And so they need to do banking business in a way that impacts the real economy. So my first question would be for Mr. Shobowale. Mr. Shobowale, just like I said, recapitalization is currently ongoing, and it means that at this point, the banks will have a lot of capital at their disposal. And we know that banks mostly invest in fixed income securities, government bonds, which is a safer investment for them. And I know that it may not be sustainable to do this when you have over 500 billion in your coffers. So what innovative strategies do you think the banks can employ? Or rather, do you think that the CBN is open to allowing banks to be innovative in a way that allows them to deploy their capital to maybe by way of transferring performing assets or securitizing their assets?
Thank you very much, and good afternoon, colleagues. So first, I'd like to disagree a bit with the premise. So it is not quite true that banks mostly invest in government securities. Government securities are safer and therefore more attractive. But in taking the investment decision, you obviously will look at your risk. And when we're talking about capital, don't forget that the banks have gone out, to market institutional investors, market individuals, promising them a rate of return on the capital that they're giving to the bank. So the banks have a duty to return those investments back, at a premium or at a sensible rate of return. And so that will guide their credit assessment in terms of what they put money into. And it's a balance between, opportunities that you see in some of these emerging sectors and the risk inherent in it. What I think that the CBN can do is encourage investments in maybe sectors that you may call critical, right? But leave the final decisions to the banks who are answerable to their shareholders to do. Now, the other thing is that banks also need to strengthen their institutional capacity to be able to assess credit for some of these emerging sectors as well. And, the final thing I'd like to say is that obviously a big part of all of this puzzle is the enforcement of a lender's right in a borrowing relationship. And that's where the law and the judiciary comes in. So when we begin to get, our acts together or the reform measures taking roots in these different areas, I think that banks, will step up, their creativity or innovativeness and take on a little bit more risk. Of course, bearing in mind that they have the owners of capital to answer to.
Right. Thank you very much, Mr. Shobowale, for that response. And my next question will be for Mr. Dawodu, flowing from the question that I asked Mr. Shobowale. Do you think that the existing regulatory regime limits innovation, especially when it comes to risk reduction mechanisms for banks, risk-weighted assets, or transferring capital or transferring performing assets from the banks to other existing bodies, maybe like the pension funds? I'm saying this in light of the fact that if you look at the letter from the CBN that asks banks to recapitalize, they seem to have stated that if you do not meet your capital adequacy, you need to inject fresh capital. And I know that in other jurisdictions, that is not the way they do that. I mean, that's one of the ways, but you can't continuously go to the market to inject fresh capital. So they will usually sell off some of the performing assets to reduce the risk-weighted assets that the bank has in order to meet their capital adequacy regime. So do you think that the CBN will be open to these kinds of innovations for the banks, especially as it is obtainable in other jurisdictions?
Okay. Good afternoon, colleagues. From my own perspective, I'm not sure that we have a situation where the CBN is trying to fundamentally limit innovations.
The bank is a bit far from it.
I'm not sure we have a situation where we have the CBN limiting innovation.
I believe that the current situation we have provides opportunities, and we also have some challenges. The challenges have to do with the CBN or regulator trying to ensure that there is regulatory balance in the system, and that's their core focus, to ensure that consumers' deposits are safe, there's financial stability, and then that the banks practice sound banking practice. This function, in a way, would slow or hinder innovations, but it does not stop, or does not mean there's been a prohibition to innovative solutions in terms of credit risk. Also, I'm aware that the CBN has some innovation channels. We have what we call the regulatory sandbox, which provides a controlled environment which the financial institutions can test new products and services while ensuring that there's risk reduction before introducing to the open market itself. Also, I'm also aware that there have been several innovations from the regulators in terms of open banking. Yesterday in the papers we were reading that they want to link the NIN to your passport, to property purchases and every single thing, and that's all part of the regulator supporting innovation in the market. Also, we are aware that the regulators are trying to deepen the market and drive reform in the market, and we expect that within the next 2-3 years there will be a lot of development in terms of asset securitization and derivatives in the market. Thank you.
All right, thank you very much, Mr. Dawes. I'll still stay with you, and so I'm asking particularly about innovations or innovative structures that would help maintain capital adequacy. Like I said, reducing risk-weighted assets as opposed to just injecting fresh capital. Are there other mechanisms or structures that can be implemented that will be allowable by the CBN?
Yes, so there has to be a deeper market knowledge of those products. And I think that's already in place from discussions with some external counsels. I understand there's been some engagement with the CBN on those matters. And then also for the financial institutions also, they need to have a better understanding of some of these products before they start implementing them. Thank you.
All right, thank you very much, Mr. Dawodu. Well, my Lord Honorable Justice Faji, my next question is for you. I'll go to Prof first before I come back to you. So, Prof, I understand that the CIBN is responsible for maintaining professional conduct in the banking industry as well as promoting trainings. Now, I know that CIBN often convenes stakeholders, engagements, and all of that. Do you think that the CIBN can play a more active role in ensuring that there's a synergy or collaboration between the regulators and the banking industry? I know that you do a lot of that, but could you be more active, especially when it comes to allowing the CBN ensure that banks are, I understand that most times they are a bit stringent because, I mean, this is people's money that we're talking about, so they need to have stringent mechanisms implemented for the banks to function. But do you think that you can advocate for a better framework that allows them to be more innovative than they currently are, like I said, to impact the real economy? Because we know that currently the banks are not impacting the real economy as they should. So are there more active roles that you think that the CIBN can play in that regard?
Thank you, Tare, for that question. And let me thank the organizers of this program for counting it worthy to invite CIBN to represent, though I'm a lawyer, but nevertheless, I'm representing the Challenge of Bankers of Nigeria. I believe it would have been wrong. And in most cases, you find out that you cannot shave somebody's head in his absence. So, coming here today, I'm here to represent the Institute as a finance lawyer. And I can say categorically that for this discussion to us meaning, I will first of all want to go through the act that established Challenge of Bankers of Nigeria. That's at number CIBN at number 5 of year 2007. If you look at the three, Section 3 of that Act, it makes it abundantly clear, A to D, the duties of CIBN. The very first one is for us to set the standard of knowledge, among our members. That we have been doing. 2, like you mentioned the other time, is to keep the registers of all members so that if any of them should commit any infraction, we should be able to deal with them. And fortunately for me, I've been on the tribunal for some years, and I knew that I've sanctioned so many bankers who engage in one infraction or the other. Also, there is also the duty of us, making sure that our members are ethical and professional in what they do. These are some of the things that we have been doing. Now, coming to your question as to whether we have been doing this, I can give you 100% assurance that we have been doing it over the years. I came from Abuja today, and one of the reasons why I came this afternoon for this program is for us to be able to exchange ideas, among ourselves. For the past 25 years, we have been running a judges conference, a seminar, where we call all the judges in the federations, all the states of the federation were represented, and thank God my learned Sikh, Mr. Zaro, was there with us as one of the panelists, and it was a very robust discussion, talking about the way forward, and now we can work together effectively. We have been serving as an arbiter, and we want to give examples. We have been serving as an arbiter between the regulator and the operators, because we have an independent, power that is different from, we are not regulators, we are just to set standard. And that setting standard is also very key, because Bible says my people perish for lack of knowledge. So what we have been doing is that anytime there are major issues, we take it up as if it's our own personal issue. Number one, when I came in about a year ago, there was this calling of the MDs incessantly by the parliament. I went there, had a discussion with them on the way forward. And today we have a center within the parliament where basically can easily be passed to the MD, rather than calling the MD to becoming one-on-one. Also, we on our own, immediately the new CBN governor came on board. We have to approach him that this is my agenda, what would you call it, the legacy agenda. What is our own agenda? He said reset. And how can we reset the economy? How can we leave a legacy of excellence and professionalism if we are not going to work together? And with the number of things we are doing together, which I believe will materialize in due course. So we reached out to ICPC, we signed an MOU with them that, look, it is true that you are law enforcement agents, but you have limited knowledge in the areas of finance. On our own, as part of the contribution to the system, let us come intermittently to educate you at no cost, to the system. These are part of the things we have been doing for those people. The same thing. When this issue of recapitalization was mentioned, on our own, we organized, an advocacy series, educating people on the implication. And what I can still recollect vividly, one of the submissions made at that something is that the issue is not issue of the quantum of capital that is coming into this country. How do we utilize the capital? You understand? You can come with so many capital. There are a lot of bottlenecks, a lot of challenges that banks are facing under it. Today, thank God, through operators are with me on this panel. They will tell you that there are times the liquidity was not their problem, but they can't finance, those people who will not pay back the money. Experience has taught us, even from the data from CBN, that 80% of the debt being owed to banks are being owed by less than very few group of people. What has the system done with those people? And that's why we need a nexus, a collaboration with the judiciary to make sure that these people will not go all over the place, to continue to borrow from one bank to the other without paying back. So no banks will want to, give out loan when they know that the loan will not come back. Remember that the whole banking is based on the principle of financial intermediation. You collect this money from people, you invest it for them, and you give them assurance that anytime you come, you will meet your money. So we, on our own, we have been doing that, like I said, and we have even gone beyond, that in looking at the society at large. Because banking is a microcosm of the macrocosm. And we believe that one of the problems we have in the bank is that a lot of them are facing the challenge of the the perspective of the generality of the populace. And we, on our own, some years ago, we started a legacy project in most of the tertiary institutions, building state-of-the-art, theaters and everything. And the regulators are very pleased that we are doing that on their behalf. In touch, the issue related to tax the other time, we were there to intervene on their behalf. And that was why there was a minimal reduction in what they had to pay. So we will keep on doing that. We have been doing that, and I can assure you that we'll continue to do that. Thank you.
All right, thank you very much, Professor. Thank you for that response. So my question to you, my Lord Honorable Justice Faji, from a judicial standpoint, what role do you see the courts playing when it comes to ensuring financial stability, especially promoting investor confidence? Because I know that the judgments that the court gives would have a way of impacting the confidence of investors that want to come into Nigeria, especially those that want to invest in the banking sector.
Thank you. Of course, you've mentioned the first part of it. An efficient judicial system or an efficient means of dispute resolution is imperative for encouraging foreign direct investment. Decisions of courts have an impact upon the economy. And of course, uninformed decisions also have a contrary effect on the economy. So what we are looking forward to as courts, from the courts, is that the courts must efficiently and quickly dispense with cases. The judgments of the courts must be predictable, they must be sensitive, commercially sensitive, and they must be clear, so that counsel and parties are able to determine what the position of the law is at any time as regards the transactions they are likely to go into. So, in the banking industry, the courts, and in view of what's going to happen next year, the courts need to understand much more better the architecture of the financial industry, know how the industry operates, and know the likely effects of your judgments when they are pronounced on the industry. Of course, we'll be faced with a lot of innovativeness, a lot of creativity as we approach March next year, and the courts have a duty to familiarize themselves with financial products like innovation, assignment, sub-participation, and all that. And courts also should be more proactive in the enforcement of collaterals. Of course, we still have the ghosts of Savannah Bank and Agilo still haunting us about the effect of lack of consent to a mortgage. The Supreme Court in that case decided that the mortgage was void, but of course there's still an underlying obligation to pay the debt. So these are the things that we need to do as judges, and when we give good judgments, we are proactive in the way we give our judgments, then the economy revolves and it has an impact on everybody generally. That's how I think the courts should progress.
Thank you, my lord. Thank you so much for that. So I'll go to the next line of questions. Like I stated at the beginning, we'll be considering 3 different areas: judicial enforcement, standardization of banks' documentation, as well as innovation by the banks to carry out activities that will impact the real economy. So I'm going to go to the documentation. I know that documentation is a large part of the banking framework, and especially with the BALPA 3 that advocates for implementation of credit risk mechanisms in documentation for banks. Now, with banks having a lot of capital, and then I believe that there will be more deployment of capital to people who seek for loans, maybe companies and individuals who are seeking for loans. How well do you think that the banks are implementing these credit risk mitigation mechanisms in their documentation? Mr. Dawood, sorry.
Oh, sorry.
Yeah.
Okay, well, from my own perspective, and I'm very sure I speak for my colleague over here also, the banks have been they've really strengthened the documentation process, and they have uniform credit documentation that we adopt. Depending on the complexity of the transactions, we also have need to discuss with our external counsels and local counsels for transactions that involve cross-border transactions and all those things. You get legal opinions, you get the legal drafting properly. and we also have subscriptions and membership in all various industries like the Loan Market Association to ensure that you have the right conditions or clauses in your agreement. So for that, I'm very, very sure that the documentations are very okay. I think the challenge we've always had has been the understanding of those documentations by the local players and the discipline to keep to the terms of those documentation, and then also enforcement. So, but in terms of credit documentation, they are always okay. They are always very robust, and they do cover the relationship between the bank and the counterparties very, very well. Thank you.
All right, thank you. I know that not all of us here are banking lawyers, so some of the terms that we use might not be understandable, so to speak. I know I mentioned BALPA 3 framework. So the BAL framework is a framework that is applicable to banks, international framework that is applicable to banks that they need to adopt to ensure that they perform effectively. It covers capital reform, credit risk, liquidity risk, and all of that, just to ensure that there's an understanding of that framework. So whilst we're talking about it, you understand where we're going to or where we're coming from. And also to mention that I know the first set of questions we're talking about the regulators, and some people might be wondering why we don't have a regulator on the panel. We did have a regulator, but unfortunately he was unable to make it to the session. However, I know that there's a representative from the CBN, so if there are any questions that have been asked here that you want to respond to when we throw it open to the floor, please feel free to do so. I know that I don't want a situation where it looks like we are talking about the regulators without them having an input in the conversations that we're having. So when it's time for the questions, Q&A from the audience, a representative of the regulator would speak on their behalf. Thank you. Now, my next question is for you, my Lord Honorable Justice Faji. So as financial instruments and loan documentation become sophisticated, what do you think are the relevant support systems or mechanisms available to the judiciary? Because, like I said before, in order for you to adjudicate on a subject, there needs to be an enhanced level of understanding. And I know that there are some nuances in financial documents, especially things like transfer mechanisms, innovation, and all of that, that the judges need to understand in order for them to adjudicate on those matters. So how well do you think that, or how available do you think there are resources for the judiciary to be able to adjudicate effectively on this matter?
Now, over the years, we have transited from one stage to the other, and at every point in time, I think the judiciary has been able to acquit itself creditably. In the days of the fiscal checks, in the days of the failed banks and deposit insurance, in the days of electronic banking, fintech, and now that we have the distressed assets regime. We're now going into a system of recapitalization, which is going to expose the banks or make the banks be more creative in the way they run their business. So I think on a continuing basis, judges need to be made more aware of what their responsibilities are. And for me, it's also a matter of being able to put the particular transaction within context, to be able to know what the transaction really is for the judges to be able to apply the legal principles that are applicable. Basically now, of course, over the years, we've always had judges we've always had lawyers who had commercial experience being appointed to the bench. So in terms of capacity, in terms of human capacity, I think on a daily basis we're improving. The recruitment process also looks at the various areas of particularly the Federal High Court's jurisdiction where we'll need manpower, and we try as much as possible to bring in those that have a knowledge of commercial law. We also have in-service training at the Federal High Court. What is most important, however, is the need for a mindset requiring continuous learning. So on a daily basis, judges like every other person must be ready to learn and relearn. Learn, relearn, unlearn, but learn. And of course, need for practical institutional training. Prof has already spoken about the various capacity building exercises that the CIBN has been extending to the Federal High Court. We also have a lot of training programs under the auspices of the National Judicial Institute involving SEC, Securities and Exchange Commission, Nigerian Communications Commission, and some other stakeholders. And then, of course, we shouldn't look only to the judiciary for the resolution of disputes. Banking is a technical subject, so I think also there is need for some kind of institution-based dispute resolution mechanism. The banking industry should, as much as possible, have within themselves, within it, a dispute resolution mechanism that would be a line of first resort before you come to the courts. That ensures that by the time the cases come to the courts, most of the technical areas have been sorted out, and what the judges need to do are things that are more of everyday knowledge to them. That's how I think we should proceed in this area.
Thank you, my Lord, Honorable Justice Faji. So before I ask my next question, Mr. Shobowale, I'll just take a cue from what Honorable Justice Faji said about having a dispute resolution mechanism by the banks. Is there something like that? I know that there's an ombudsman in the banks. How effective is that?
Okay, well, all banks are required to have that framework in place, but obviously the success of any resolution framework will depend on the confidence that stakeholders will have in it. So many of our customers, channel their complaints, but I don't think that there's huge confidence in the ability of the in-house bank ombudsman to meet their needs. But there are other channels. So there is the dreaded Consumer Protection Department of this Central Bank of Nigeria, and many savvy customers make their way there. But there's also the Subcommittee on Ethics and Professionalism of the CIBN, which consists of experts in the industry, including lawyers, and sits over banking disputes. And even when customers or banks go to court, now because of the specialized nature of some of these transactions, my preference would be that sometimes the judges who are sitting over those disputes should perhaps refer some of those technical aspects of the dispute to some of these bodies and to act as referees, and then receive their reports, obviously under the right fairness framework, and ensure that they do justice, but based on contract. So what more can the banks do? I think that, we're used to include dispute resolution clauses in the loan documentation. I think that we should go beyond the standard ones, right? And begin to include a mechanism like referrals to the CIBN Subcommittee on Ethics and Professionalism, and perhaps even insist that before you institute a court action, you should exhaust some of these ADR mechanisms. I think it would be better if the customer and the lender sign off on that framework, and that is then enforced by the judiciary if someone wants to skip, a step before the ADR step before filing a formal court action.
All right, thank you. Still on you. You mentioned the courts referring some of the issues from the banking sector back to the banks to have a dispute resolution mechanism that would settle all of that. Has there been conversations with the judiciary on this matter, or is it just something that the banks are thinking towards, but there's no concrete discussion on that? Okay.
Prof is probably the expert on that, but I'm aware from attending sessions of the annual Judges Conference that the role of the Subcommittee on Ethics and Professionalism has been highlighted to the judges who attend those sessions. And I do know that in very many cases, many times, the judges, even on their own motions, when they see that the issues are technical, will say, okay, this particular narrow issue, we would like to have the benefit of the opinion of that subcommittee. Or sometimes they invite the CBN, they refer particular parts of the dispute to the CBN to review. Sometimes the disputes are about, I'm owing you 10 naira, you are owing me 20 naira, you didn't calculate the interest correctly and all that. You'll agree with me that that would be tedious for a judge to sit and determine. And many times they make those references, and those reports are brought to court under the right framework to ensure fairness, and they're used to enriching decisions and settling disputes.
All right, thank you. Professor, would you like to respond to my question?
Yes, just to confirm that we have a system in place, to reconcile customer, banker, customer and bank when there is conflict. Like it's mentioned, we call it the subcommittee on ethics. And last year, I could recollect vividly that we received about 474 cases, and we completed 171 cases. We resolved it. And also, we were able to get about 544 million into the system. And it's very simple. What happened is that the moment the judgment is passed, like my colleague rightly mentioned, we have experts there, people who are lawyers, people who are finance gurus, MDs of banks and everything. The moment there is a pronouncement there that a party is guilty or has done something wrong, immediately we advise the CBN, and immediately the account will be debited. So there's no question of going back. And like I said, it's a means of resolving such conflicts. And in addition, like I did mention before, we also have a tribunal. CIBN tribunal is incorporated in the CBN Act number 5 of 2007 that can adjudicate on matters, pertaining to members. The only thing is that it's just within the members only. That's for the issue of a tribunal. But the subcommittee is open to everybody. Whether you are a customer outside, you are not whether you are a customer within the ecosystem, Nigerian ecosystem, you are free to do that. And apart from that, I could recollect that every year we have a representative in the multi-door something. So just to make sure that some of those little cases that we can handle ourselves will not go, or in cases that are very clear to all parties. I'm owing you have debited my account wrongly and everything, and the evidence is clear to both parties. Then there is no need going to court because of time frame. And court is already loaded, in that respect.
Okay, I'm sure most people want to know, so how can we access this? Because I know that a lot of people are having issues with
yes.
with their banks, so to
that
speak.
Is why I said the other time that in this kind of a program, a conference, there is need in future, anything that has to do with finance and law, they work pari passu. They should invite somebody who's in that field to provide information. It's readily available. Like I said, this something I quoted now is from my annual report as part of my achievement within the 1 year in office. So it's there, and we advertise some of them in our journals and everything. And when you call us for this kind of an arrangement, then we'll be able to tell the public it's readily available. All you just need to do, write a letter of your complaint and everything with necessary documents, then you send it to the registrar, and it will be passed out to that committee. Because that subcommittee is the committee of all the bankers committee in the country. So that's why we call it subcommittee, because it's not actually being handled by the bankers committee. But CIBN handled this for them. No. So
thank you very much, Prof. You have heard from Professor, and so if you have issues with banks, that's the place to go to make it easier for you, because I know that most times people complain that, I've been wrongly debited and I don't know where to go to. This is an easier way for you to resolve all of these matters. Thank you very much, Professor. My next question is actually for the bankers, Mr. Shobowale and Mr. Dawodubo. I'll come to Mr. Shobowale first of all. I've had conversations with a lot of banks, and one of the things that they say is our documentation, we need to ensure that it's very simple and ensure that it's not very lengthy, because if we do that, we'll be chasing away the borrowers. They would rather go to, there's a competition from fintech, because for those ones, you don't even need long documentation. You just click accept, and that is all that you need to do to access funds. So there's this complaint that if we make our documentations very stringent and very lengthy, we might lose the interest of the borrowers. So I know that in order for you to, because there are a lot of non-performing loans that sometimes when you look at banks' balance sheets, you see that they have a lot of non-performing loans, which is obviously from borrowers that cannot repay these loans. And I know that it boils down to the documentation of the bank. If the documentation is more watertight, if credit risk mitigation mechanisms or strategies are implemented in this documentation, it will make it easier for them to recover some of these loans. So what do you think, from your own perspective as the head of legal for Union Bank, what do you think the banks need to do to ensure that there's a watertight agreement, or they prioritize credit risk mitigation mechanisms in their documentation?
Okay. Well, thank you very much. I mean, I'm all for simpler and faster, but don't forget that you are managing other people's money. So, so you have to tailor your documentation to the level of risk that you are assuming. So, I mean, for most retail loans, for example, maybe a 2-page document, I mean, in fine print will do. But if you are lending money in excess of, ₦1 billion, I mean, you'll agree with me that if we do a 200-page documentation, I don't think that the borrower should complain. So really, it's just to tailor your documentation to the risk that you are assessing. Obviously, you also look at, you profile your customers. There's no point in giving a 100-page or 50 pages loan agreement to a farmer, who's never, been to school before, or maybe didn't, go past secondary school. So obviously, you have to look at the risk, you have to look at the customer, but it's a balance, really. I mean, if you are taking on large risk, obviously you need a contract that is watertight. I mean, we've all moved as a profession. This is not just about the banks now. As a profession, we've moved away from, large, verbose documents with a wearing for and hearing after, regime. But even given that, you still need to make sure that you cover all the basics. You have information undertaking, your covenants are exhaustive, and so on and so forth. So it's really about managing risk and tailoring your documentation to the level of risk that you are taking.
Thank you. Mr. Dauju.
Okay, so I quite agree with what he said. In my own institution,
Your mic being struggling to hear.
Sorry. In my own institution, what we've done is that, like, for the consumer loans, we've actually moved from 20-page documentation to like 2 pages or 3 pages documentation. So for your asset acquisitions, for your salary advance and all those kind of facilities, you are basically signing a 1-page documentation, and it's something that can be done within 24 hours, 48 hours. As you said, the more complex the transaction or the higher the risk or quantum of the facilities, then you start having more documentation, just so that parties are quite aware, and you have covenants and obligations and boilerplate clauses that normally apply to those complex transactions that you have to include in the agreement itself. In terms of the documentation covering the risk, I think the industry position is we are moving towards less documentation also. Parties are becoming more aware of the transaction dynamics for most of these applications. The consumer base is also becoming more educated, so there's more understanding. So where we had to put maybe like 5 or 6 clauses, 1 clause may do. With the development in the judgments that we've also been delivered over the last decade or so, the banks have to react and make things a bit more simpler. Thank you.
All right, thank you, Mr. Daudu. Yes, Professor.
I want to say something about the issue of documentation, most especially since the operators are here. One fundamental problem with documentation is that people just take documents from another bank, mutatis mutandis, and just adopt it, even inside. And the danger with that, which we have seen a lot of people having problem at the end of some banks having problem. I've seen a bank where that he uses the document of another bank and he has forgotten that it's a place, I don't want to mention the name, that there is a place where the name appears below. The moment you made that mistake, you are already in crisis, in problem. So my admonition to our practitioners is that I know that banks are looking for profit and everything, and thank God they are making trillion. They should allow lawyers to live and allow this brief, give it out, let experts look at this document and sanction it as document that is there. Not somebody in-house who has not gotten the requisite experience doing the documentation, and at the end of the day, when the problem comes up, then you run back to the same thing. It's like somebody being penny wise and yes. So please, I believe that we should carry that. We have been telling them some of these in the course of our discussions with them, from time to time. I just believe I should just ship that in terms of these documentations.
Yes, thank you for that. Just to reiterate what you said, I know that sometimes you look at some banks' documents and you see that there's a mismatch of clauses. Yes. The document is a term loan, and then you see things like payment on demand, yes, call on loan, and all of those things that are applicable to an overdraft. So most times you can see that there's obviously not an understanding of what those clauses imply before it's inserted in documents. So just like you said, it just lift up clauses. So I think the banks need to, just like Professor has said, most of the time they may not have the understanding of what those documents are, but you need to speak with professionals who can properly draft these documents better than you do. There's no harm in moving from admitting that you're probably not the authority when it comes to certain things. So now I'll come to my Lord Honorable Justice Faji. I know that we spoke about the financial instruments that are available in the banking sector and the fact that the judges might not, they need to have a better understanding of how those financial instruments operate and why they are even provided for in some documentation in order for them to adjudicate on it. So I don't know if you have something else to add to that.
Basically, the three most prominent ones are assignment, innovation, sub-participation. These instruments are legal terms in the sense that lawyers are familiar with assignments. I mean, transfer of an entire interest in an item, in writing, notice to the obligor. Where the challenge comes in is where there is an equitable assignment or a further equitable assignment. Then, of course, the courts need to look at the character of the transaction, look at the context of the transaction, and then be able to give it what would be called a legal characterization. So a document could say it's an agreement, whereas it's a novation. So it could say it's a novation, whereas it's just a simple contract. So whatever name is given to the document, the courts need to look at them and then look at what they actually mean in law. Concepts have grown, legal concepts have grown from time to time by analogy. And many of these concepts that are now being used in the financial services industry are concepts that are known to law. It's just that the judges would have to look at the transaction and then be able to say, this is what this transaction is. So for me, basically, I mean, sub-participation is probably just fractionalization of an interest. So for me, it's more for the judges to understand the context of the context in which the transaction is being done, and then the words being used, and then attach legal consequences to them. And I think that as time goes on, we get more familiar with the particular kinds of instruments, and then it will be easier for the judges to decide on them.
All right, thank you very much, my Lord Honorable Justice Faji. And just like you said, it's important for the judges to understand transfer mechanisms. I mean, the day-to-day contracts, it's not so different from financial contracts, just that financial contract is a three-way contract, it's a tripartite contract. So you need to understand the importance of transferring from one party to the other and to the third party. So that knowledge is very important. So that brings me to my next question for you. Do you think that it's necessary for the courts to have, or for the judiciary to have specialized courts for issues relating to commercial contracts or even financial contracts? Or do you think that they should have judges that are trained in this particular area? Because banking is a specialized area. Do you think that they should have judges that are vast or trained specially to adjudicate on issues that boils down to the banking industry or the financial industry as well?
Well, there are two ways of looking at it. It's one, to create a separate court, or to have streams for judges in a particular court. Of course, creating another court for financial services may not be necessary. But as it is now at the Federal High Court, we do have various streams of judges for particular financial issues. For the AMCON, EFCC, FIRS, we have various streams like that. So for me, it's more like specializing the judge, identifying the judge that has knowledge in that area and then honing his skills. Where you find that you don't have that in sufficient number, have a continuous training program for them. So over time, people tend to learn more when they do a particular thing more often. So I think it's a matter of actually specializing the judge and making sure that the judges have the necessary training that will enable them to do their work more efficiently.
All right, thank you, my lord. So my next question is for Mr. Shogowale and Mr. Dawodu, still relating to the question that I just asked my Lord Honorable Justice Faji. Do you think that or in what ways do you think that the banking industry can constructively engage the judiciary to enable them understand complex financial instruments or documentation? Because it feels like there's no synergy between the banking industry and the judiciary. I might be wrong, but that's what it seems on the face of it. So what do you think the banks can do to ensure that the judiciary comes up to speed and have the same understanding of financial instruments and banks documentation?
Okay. Well, it's a good question, but don't forget that the judiciary is supposed to be an impartial arbiter. So the banking industry needs to be innovative about the way it engages the judges. So what is the industry doing today? Prof, our president has just, spoken to the seminar that's been taking place in Abuja, the NJI, over the course of the last 2 days. And that program is called Seminar on Banking and Allied Matters. And so they focus on, some of these aspects, and they bring judges together periodically to engage. I would say that should continue. I would say that the regulator as well should also play a role in that. I mean, they are already key participants in this CIBN program, but I don't see why the CIBN itself can't organize periodically sessions for judges where experts, both from the industry, from the academia, and from practice, sit with the judges and basically exchange ideas. The experts will deal with the technical issues, the judges will ask questions, and everybody will go away with a better understanding. Now, if I look at what is done in other jurisdictions, even in the judiciary, you regularly have guidelines on different things. I mean, in the realm of criminal law, for example, there are guidelines on sentencing. And so if we begin to develop guidelines on the different areas where disputes can arise and come before the judges, I think it will sort of provide a background or some sort of support for the judges who are sitting over these cases. So I'll advocate that we have guidelines around the resolution of lending disputes, for example, or maritime asset securitization, and so on and so forth. And I think that the more of those that we have, the more of an institutional framework we would have for our judges to rely on and to dispense justice impartially and to the satisfaction of all the stakeholders.
Thank you very much. Mr. Dawodu, how do you think the banks can engage the judiciary?
Okay, so my lordship and session have spoken to some of the points I would like to focus on. But apart from what they've said, some of the things I feel would assist will be, one, the banks providing expert witnesses in their cases, rather than just a staff of the bank, especially when it goes to legal principles. You bring forward maybe a professor of law, or bring forward a former deputy governor of the CBN, who can explain the concept of why the principles behind some of the, or the underlying principles behind the transaction in disputes. Secondly, I feel the bank as an industry, and we've done this session and I sit together on, or sat together on an association of bank legal advisors, should come together and jointly also file amicus briefs, to assist the judges in understanding some of the matters they are reviewing. And lastly, I feel that in some other jurisdictions that I've experienced, because there are two things you're looking for. You're looking for justice and you're looking for quick turnaround of those cases. I feel we should also be looking at having maybe a body of experts to assist those judges who they can refer matters to when the pleadings come in, to prepare a report on the issues and also provide legal advice to the court itself, which the court can rely on in fundamentally resolving the dispute between the parties. So those three issues, I think, will go a long way. Thank you.
Thank you very much, Mr. Dawodu. So that brings me to my final question. Professor, based on the responses that you've given, I know that the CIBN is doing a lot, and thank you to the CIBN when it comes to trainings for the banking sector and those who work in the banking sector or for the banking sector. Is it possible to have a dedicated training session for just the judiciary as well as the banks on financial products, financial instruments, banks documentation? You probably already have that going, but is it possible to have, because I know that, like I said, there are already other training sessions that are available, and you just concluded the seminar for judges, which I have attended before, and I know how productive that was. So is it possible to have just a dedicated session that is ongoing or continuous? Because learning is a continuous thing. So, of course, there will be people who will be elevated to the bench that will still need this sort of training. So is it possible to have a dedicated session for that?
Yes, thank you for the question. The truth of the matter is that our training program is not limited to the judges conference alone. The problem there is problem of communication, which is part of the thing we are likely to achieve with this conference. For example, I'm aware you were in the UK with us, you realized that we did something on AI, and there were issues relating to law, to finance that were mentioned and were discussed exhaustively. I believe such a thing is what you can replicate here. And in addition, apart from the judges conference, we also have what we call advocacy series. When we see a particular problem that is confronting the ecosystem, and we believe that we need to look into it, and I will give an example. We realize that one of the fundamental problems that we have in Africa is that our payment system is normally rooted to Europe. And we look, and in doing that, we lose money. There is also a problem of delay. And we discussed with Afrism and said, how can we tackle this problem? We have knowledgeable people around, and we came up with a new payment system that some banks are already keen to it. You know, when something is new, many people will still be agitating here and there. But the truth of the matter is that it's something that has been working. Some banks are already keen to it. Such things, when we are doing it, we invite everybody, because it's an institute that must educate people on issues related to finance. We do that from time to time. I'm just giving that as an example. And today, payment system, if you are doing a business with somebody in Ghana today, you don't need to route your payment through this thing. You just go through the Afrism payment system. And we have a certification in that respect. And also, there is something that is still lying fallow. As I was coming, I informed one of my directors that we must take up this challenge. We have a certification. You know, we met the leadership of both CIBN and NBA met some years ago, and realized that in the business session, there is, especially for those who work in the finance area, there is need for them to have a knowledge about this loan documentation, you know. And we came up with a certificate. And I'm glad today, 2 or 3 of my students who came here to give me, in Babcock, is part of the additional things they get before leaving that school. You get a certification in loan documentation and processes. So we have been doing that, and like I did mention, we will continue to do that. Advocacy series from time to time is open to everybody. Some of these are advertised. Our Banking and Finance Conference is coming on the 5th and the 6th of September. You are cordially invited, so that we see, because we have gone global, and that is the truth. Because as of today, we are the permanent secretariats of the Association of Banking Institutions in Africa. I was the one who led the team to go and establish the institutional framework for the East African something when I came in as the president.
Put your hands together
so there are
for
so
the
many
CIBN.
opportunities.
They're doing a lot.
So I just want us to work together so that we can raise the bar. Thank you.
Thank you very much, Professor. So like I said, that brings me to the end of this session from the panelists. We can take questions or comments or recommendations from the floor. Like I said before, we don't have a regulator or representative from the regulators here on the panel, but we have one in the house. And if you would like to respond to some of the comments that were made here.
Tare, since we have an adage in CIBN that the only difference between CIBN and CIBN is the high. So what that connotes is that there is hardly anything that is happening in CBN that we cannot tackle. So I can't be here and you want to raise any issue on CBN, I'll be up to the task.
I apologize. That is very much noted, Professor. But we can, yeah, okay, yes, there's a question. So I think we have time for a number of questions. Your name, sir, and where you're speaking from, your organization.
Good afternoon, everyone. My name is Femi Fajolo, partner Geoshodekwan Company. My question is directed at the professor. Prof, I know the banks are trying their best, online banking and everything, but what we face in the market now is that you want to do a transaction, even at the E3 halls, they tell you they're not accepting transfer. And the reason is simple. You transfer money and it goes back to you. So these days, if you don't have your cash or POS, I mean, what's it, a card, debit card, they tell you they won't accept transfer. What is going on? What can be done about this? Thank you, Prof.
Yes, the fundamental issue here, this where law comes in. One of the efforts we have been making is that some of those people operating at that level, they are not captured in year 2007 Act. As we are talking, the amendment to our Act is already on the table of the President. I believe is that before the year runs out, we'll be able to capture everybody in the ecosystem. The banking system has expanded beyond what we used to know. The fintechs are not covered. All we are trying to do at this moment is to use moral suasion. You know Nigeria, when the issue of moral suasion comes in, it can jettison it and say, I'm not a member. And as a lawyer, you know the importance of jurisdiction in this business. So we are aware of those problems. We are aware of regulatory laxity. Like I said, we are working with CBN, and I believe by God's grace, if we are able to get the act, then we have something that will be an enactment that will guide everybody operating in that system, so that we can raise the bar of excellence that we adopted. But these are the teething challenges that we are likely to face for now, because the truth of the matter is that the payment system in Nigeria today, is even bigger than what is happening even in the United States of America. You understand? And we are glad for that. And there are some people who are employed there, but we must regulate ourselves so that we don't run into problems. Because in cyber crime, we've just come from a conference, and our decision is that within 1 minute, somebody can destroy your life by removing all your money. There must be check, there must be regulatory framework and legal framework that will be able to attend to that. It's noted, and we are working on it.
Thank you, Professor. We can take more questions from the audience.
Okay. Thank you very much. I have 3 short interventions. The first one, the learned professor, president of CIBN, did say that banks should allow maybe external lawyers to do more work. And I think this is a point which the MBA should take up. Because under our rules, there's some kind of work which should not be done by in-house, but which presumably is being done by in-house. I believe we have enough teeth to bite and not just be complaining, because that will create more work. The second point is to my Lord, the Honorable Justice Faji. Most courts, including the Federal High Court, have powers to call on referees and arbitrators and so on. I'm just wondering, because I don't have records in terms of the trend, whether if we, pursuant to these discussions, we make applications before the courts, whether it's the kind of thing the courts would do in terms of relying and calling on referees, because I don't think it's been common. And the last point, as the chair of the MBA journal, we're about to do the last one under the leadership of the MBA, the current chair. Professor Olanwaju did say that over 170 cases have been resolved.
Yeah.
We don't know about that. Please, can you, sir, is it possible that we have a paper on this to enlighten us, because it's going to add to the jurisprudence of banker-customer conflicts. Thank you very much.
Thank you very much, Professor Shodipo.
Yes, just to give an assurance to my erudite professor, sir, that we will look into that. What we normally do is that intermittently, we compile them in a booklet so that scholars can use it as even precedent, but we won't put the name of the bank and everything to avoid litigation. But we will, I think going forward, one of the things that I will take home is the need for us to popularize that avenue. Thank you, sir.
Yes, Professor Shodipo directed some questions to me. Babcock University is a university of professors. We have the president of CIBN here. It's quite a good thing to know that our children are being taught by people who know about the practice of banking. As regards referees and arbitrators, it's now becoming rather frequent for counsel to come to court to seek declarations, to seek the court's order that particular statements of accounts should be referred to a referee or to an auditor for the purpose of determining the liability or the outstanding debt. So it's something that happens regularly. In fact, in some cases, in the course of proceedings, the judge can even ask the counsel, now that you are disputing this debt, let us have somebody who I can appoint or who you can agree upon to look at these documents and then arrive at how much is actually due. Yes, once in a while we find situations in which the parties do not want to agree, or they agree on a process and then they leave court and then they start doing something else. But that avenue exists and is being utilized on a daily basis now in the courts. Yes. Thank you.
Thank you. Yes. Leonard Silk, Mr. Iwulamin.
I think this question is directed at CIBN, of course, and maybe a bit more sympathetic to the bankers. The admonition that the banks should give external counsel an opportunity is based on the assumption and the proposition that external counsel can understand what the banks do. What I find is those of us who are external counsel working in the finance sector, we're continuously training ourselves because it can be complex. Therefore, a lot of those who say they're in the banking sector may not have the capacity to resolve that problem. So I noticed that those who have gone to Babcock, and we have quite a few of those students with us, they seem to do a lot of work. So lawyers that can't read the balance sheet of a bank cannot provide a service for the bank. But I noticed that the people who go to Babcock, that assumption is based on the fact that you actually educate your students. It's not like that across board at all. So we don't really have true experts. The banks themselves create a problem, because we spend a lot of money trying to educate ourselves. And so when we give a fee note to the local banks, they tell you that it is too expensive, and therefore you just give the instruction to a young lawyer, and the discrepancy can be a lot because we're spending a lot of money educating ourselves. And so the bank simply say that somebody's going to provide it for a fraction of what you're asking. And they give that work to that counsel, notwithstanding the risk that is involved. Yeah. And sometimes when the risk crystallizes, it's a big problem for the bank. So I don't know how we're going to balance this.
I think the challenge should be for all of us here, all the stakeholders. When my prof mentioned something the other time, what came to my mind is that we are ready and willing. Anything that will promote excellence and professionalism within this ecosystem, we are ready to join hands with you. And that's why, they are my corporate members and individual members. And you can see me coming out. Those things were based on research and study we have done over the years. That form issue that I mentioned. Do we go ahead like that? Do we go ahead in the sense that not everybody, it may be true that we are all in the business session, but not all of us may be doing banking. But what we are saying in essence is that as many people that are doing banking, you separate the grain from the shaft. And you pick those people who are experienced. And the danger of it, I've seen it happening because I sat on the tribunal for 2 years and I see a lot of problems being created, because of poor documentation. Because when you look at the credit, a trajectory is based on 4 things. Creation, how this thing is being created, documentation, perfection, and realization. You find out that there are risks at every level. And it's only expert who has passed through the mail who will be able to identify those things and nib it on the board. So the money they are running away, where we come in is in form of advocacy, which we can do. And we can organize, in one of our advocacy series where we will invite all the stakeholders to let people know the danger. When you give it to a mushroom person and you run into problem, the thing crystallizes, then after allowing, I don't want to mention name here, in the program as we are coming, somebody is about to pay almost close to almost $1 billion. One bank, I don't want to mention their name, because he gave this brief to somebody who bastardized the whole thing, and at the end of the day, they have to start looking for a land sick. And I whispered to him, being afraid that, is it not a very costly mistake? Why are you people doing like this? Why don't you give it to the right person in the very first place and save yourself? Now the junior person is insisting that he will not take 5% for anybody to take that brief from him. He was insisting that they should give him nothing less than 7. They were even begging 7.5 when that discussion stopped. So I believe all of us are major stakeholders. Let us come together, let us run together, let us know that this system, when you look at the relation between law and finance, it's so symbiotic. You understand? There is nothing called finance without legality. If you look at the procedure I mentioned the other time, the creation of credit is based on law. If you look at documentation we are talking about, it's based on law. If you look at the issue of perfection, it's based on law. If you look at the issue of realization, it's based on law. And ultimately, when this trajectory is smooth, it leads to profitability. So that's why I just believe that we are ready to cooperate, with some of the leading lights in other professions, so that we create a new.
Right. Mr. Shobowale.
Thank you, Prof, for those comments, and Mr. Agobamian. Well, we've taken the feedback, but there are a number of things that we have to consider. Yeah. In a lending transaction, legal service is a cost, and someone has to bear that cost. And usually what happens is you split it between the customer and the bank, and then the customer complains about, interest rate and so on and so forth. But I think that external lawyers can add value, but in order to do that, they also need to upscale, in terms of skills. Yeah. I had an experience earlier this year where in a transaction, our internal customer insisted that we use an external lawyer. And we weren't quite convinced because we thought it was pretty straightforward, but eventually we engaged an external lawyer, and the work that the external lawyer did, we had to spend hours reviewing. And it's not that the external lawyer did a shoddy job, it's just that the external lawyer does not have technical, experience or insight into the nature of the transactions. So if you want us to give you more work, then you need to know a little bit more than law. Lawyers need to, get familiar with, the business of their customers. And what I would like to offer is that, yes, we use standard, documents, and I'm not advocating that in every loan agreement we have to outsource to an external lawyers. But I think that every prudent bank, maybe annually, maybe, biannually, should get an external counsel to review their suite of documentation. And I think that, that way will balance cost with expertise, and, everybody will be happy, especially the customer who has to pay the cost.
All right, thank you, Mr. Shobowale. Just to add that, I think you need the right external lawyers to work for you.
Absolutely. Absolutely.
All right. Do we have any questions? Yes.
Thank you very much. My name is Toyin Adenuga. Just to add that we need to re-emphasize the crucial need for balance and judicial prudence in granting interlocutory and interim injunctions in secured credit transactions. This is vital to protecting lenders' rights and ensuring efficacy of claims of damages when you are seeking claims. We also need to revitalize our collateral registry to boost transparency and efficiency in credit transactions, alongside championing trading performing assets to unlock capital and catalyze economic growth. Thank you very much.
Thank you, Mr. Adenuga. I think we can take one more question or comments. We have just about 3 minutes left. Do we have any other question, comments, recommendations? Okay, in the absence of that, I think that brings us to the end of this panel session. I want to believe that we had a great time and it was a productive session. Before I give the final remarks, I want my Lord Honorable Justice Faji to give a brief closing remark before I end the session.
I just want to remind us that the topic of this session is beyond capital, reforming the courts to unlock capital and drive growth. And I believe that at this session we have been able to get the keys that will enable us to unlock what we need to unlock. We have emphasized at this highly technical session the need for collaboration among the various stakeholders in terms of knowledge, sharing of knowledge, and that there is still a lot of room available for exchange of ideas. This panel exemplifies how this collaboration
Thank you,
will work.
Thank you.
I have personally learned a lot, and I think that there's need for some literature to update the knowledge of judges in this particular area. When my profile was beamed on the screen, it was shown that I'm a member of the Advisory Board of Judges for the World Intellectual Property Organization. And what we do at WIPO is that we have what we call the bench book for judges. In April, we launched a bench book for Nigeria. We have a regional bench book for Africa, and we have sub-regional bench books. What this bench book seeks to do is to bring together in a short, quick reference form the law, the practice, and other things that appertain to particular areas of intellectual property law. I think we can adapt this for purposes of banking and financial transactions. And if you're able to get that done, the gaps that exist in knowledge, particularly on the part of the judges, will be closed. And of course, even the lawyers will have access to some information contained in that literature. I also take on board all the contributions by all the panelists, all the suggestions, but I think also it's critical, as you have done today, to have more advocacy and more awareness of the issues that will arise as we approach March 2025. Thank you very much.
My Lord Honorable Justice Faji, for that quick closing remark. Just to say that I know that people say we like to talk a lot in Nigeria, we hold seminars, conferences, there's always something to talk about. But I just want you to know that we are taking this conversation away from this platform. We are moving into the market. We are currently engaging some regulatory bodies that would help us move this conversation forward. So it doesn't end here. And I want to admonish everyone to join us to advocate for a better banking system. And also to say that in the coming months, you'll be seeing a change in the banking framework, and just know that it started from the conversations that we've had here. So thank you very much, everyone, for listening and for actively participating. And thank you to the Association of Banks, legal advisors and company secretaries here. I know that there are some of the members here, and also the members of the Chartered Institute of the Bankers of Nigeria, and also other distinguished guests. My name again is Tari Olorogona. Thank you for having me.
You've heard from the key stakeholders. They have shared their insights, and they have also helped us understand how unlocking capital works. I hope that lawyers who are in charge of documentations, loan documentations, take the necessary keys and ensure that, documentations are simplified, made comprehensible to the user of the, document itself. And also, lawyers are also expected to upgrade yourself, understand the technicalities of the banking and financial markets, as well as also upgrade their knowledge in the nuances, of the financial and the financial products, we have available in the market today. I hope that beyond this conversation, we take it home, we take it back to our places of works rather, and ensure that we're able to realize, the nuggets. We're able to also, we not only realize, the insights that have been shared, but are able to incorporate these insights in our everyday work. And I think that we should also give our panelists a round of applause, for their time, for the in-depth knowledge that they have been able to share with us. But I think I would like to ask Professor Pius a question. We've talked about the banking industry, and we've talked about the frameworks that are put in place in accessing and unlocking capital. But I think it's also important for us to also factor in profiling the users of these services. It's also very important. And this should also cover the financial services providers, because in terms of the interest rate, I think it's important for the lawyers, drafting this document, be able to shift their focus from profits and be realistic about the purchasing power of the users themselves. So when we're talking about, releasing this capital, you also expect that the users are able to pay back within a short period of time. That's for financial service providers. You expect that they pay within a short period of time, and the interest rates are very, very, very unrealistic. You have 42% interest rate, sometimes 38%, and you're asking them to pay back in a month or 2 months, not considering the fact that they initially didn't even have this principal they were asking for, and now you're asking them to pay an additional 42% of interest on the capital they have accessed. So how do we ensure that the financial service providers, how do you ensure that the financial service providers are regulated, that beyond the pursuit of profits, they're able to present, a documentation that is realistic to the users, so that we don't have, more debtors clogging the system, and then we don't have a situation whereby the financial institutions don't have interest in, or rather, do not have confidence in the ability of the user to pay back.
Yes, I think the problem you are asking, let me just answer it in 2 ways. First of all, the issue of interest rate. Remember that banks is being regulated. In fact, globally, I think to the best of my knowledge, bank is the most regulated institution in the whole world. So in Nigeria, we have what we call MPR.
Okay.
If MPR is 27.6, what do you want banks to do? Will the bank be operating below that? You understand? If the rate of interest is, rate of inflation is over 20-something, remember that banks are owned by a set of people, and they want return on their investment. So these are some macroeconomic challenges that we have, and that's why we are saying all of us must be ready to sacrifice and build our country on patriotism. If you have money 1 billion today, you will start moving it from one bank to the other and be asking, negotiating money that is either very close to the MPR or even higher than the MPR. And the banks are in business. Remember, they want to dress very well and wear suits. They also have some other commitment here and there. They promised liquidity. So we have a dialectical problems. And more importantly, you see the issue of corruption. I don't want you to go into the details of what happened, but it's a common knowledge. What happened in the central bank, a few years ago. The economy was grounded, totally grounded. We were in debt. We cannot pay school fees. We cannot travel with their money. We became an endangered species globally. But the man that is there is, like I said, he said, I'm doing resetting. If that resetting is not done, the bubble will burst and we will all be in a mess. So some of us are demanding for high interest. You can't reprobate and approbate at the same time. You can't be demanding for high interest from the bank and your same bank should not also put something. So in insane economy, that's why you find out that you go to all this Europe and everything, the rate of interest is still less than 10%. It's still in 1 digit. But our ecosystem, because of our taste and everything, see all of us that is there, 99% of us are wearing foreign things. Like I see foreign shoe, foreign everything. Those things is dealing with our foreign exchange. And that's part of the problem.
Thank you, sir.
So God bless you.
Thank you.
Okay, thank you so much, Professor Pius. And at this point in time, I'll call on Professor Bankole Sodipo to present the awards to our panelists. Senior Advocate of Nigeria.
It's my singular honor to do this. The first person I want to call is my colleague in Babcock University, our immediate past dean, and the president of the CIBN, Professor Pius Olanrewaju.
Permit me to just respond that you see me talking law. This happens to be the supervisor of my PhD in law.
Congratulations, thank you. In recognition of your contributions to the MBA as a panelist. Thank you very much. Mr. Kende Daudu. In recognition of your contribution as a panelist at the MBA, I enjoyed the session. Thank you so much. Mr. Session Shibowale. I have trailed this man from various places where he's been in-house head of council. Mr. Session Shibowale, in recognition of your contribution as a panelist at the MBA branch annual conference. Thank you so much. It's my honor I'm big privilege to do this to the administrative head of the Federal High Court in Lagos, Honorable Justice Olayinka Faji, an erudite scholar. In recognition of your Lordship's contribution as a panel chair at the MBA Legal Branch Annual Conference 2025. And we are really so happy and proud about what is happening at the Federal High Court. So he, as the administrative judge, please extend our regards even to the CJ of the Federal High Court. Thank you, sir. Okay. And the session has been so interesting. I mean, timely, the questions that came and so on. And that has been because we have an erudite scholar in the person of Miss Tari Oloregun. In recognition of your contribution as a panelist, thank you so much.